So here we are in the United States District Court for the Northern District of California. Stardock Systems has asked for a preliminary injunction or temporary restraining order enjoining Reiche and Ford from filing DMCA notices. And this is the order denying that motion. And it starts. Reich and Ford created the concept for Star Control and, in partnership with Accolade, developed and published a trilogy of video games under that name in the 1990s. Pursuant to the written agreement of those parties, the intellectual property rights in Star Control were divided such that Reich and Ford held some of the rights and Accolade held others. In 2013, Stardock acquired Accolade's rights in the Star Control IP and began developing a new game titled Star Control Origins. Reich and Ford contend that Origins, as well as the promotional content associated with it, infringes upon their rights in the Star Control IP. Stardock disputes the validity of Reich and Ford's claim to ownership of any Star Control IP. Upon the release of promotional content for Origins, Reich and Ford sent GOG and Valve notifications of infringement pursuant to the Digital Millennium Copyright Act. In response to Reich and Ford's DMCA notifications, GOG and Valve removed Stardock's promotional content from their platforms. Stardock filed 2 counter-notifications. Given the pendency of this action, however, the content was not replaced by GOG or Valve. Stardock recently announced the release of Origins. Stardock anticipates that Reich and Ford will send DMCA notices to GOG and Valve regarding Origins, resulting in its removal from those distribution platforms. Consequently, Stardock filed the instant motion for a preliminary injunction to enjoin Reich and Ford from sending further DMCA notices directed to material that is the subject of this present litigation, and in particular, Star Control Origins. Having read and considered the papers filed in connection with this matter, and being fully informed, the court hereby denies the motions for the reasons stated below. The court starts to go into some background here, and the court notes that the factual background of this action is expansive, and they have included only those facts essential to the resolution of the motion. The classic Star Control games. In 1988, Reiche created the concept for Star Control, a space exploration video game franchise that involves various alien species with unique names, appearances, ships, weapons, and backstories. In October of that year, Reiche and Accolade executed a license agreement whereby they agreed to develop and publish 3 Star Control video games. Accolade was granted an exclusive license to publish the games in exchange for the payment of an advance and royalties. And there's a footnote here. The license agreement conferred a perpetual license to Accolade for as long as each work or derivative work continued to generate royalties in an amount of $1,000 per year. Under the license agreement, Reiche retained ownership of the copyright and all other proprietary rights in the work, while Accolade owned the title and any trademarks adopted and used in the marketing of the work. Reiche and his longtime business partner, Ford, created and developed Star Control, which Accolade published in 1990. They then created and developed Star Control 2, the Urquan Masters, which Accolade published in 92. Reiche and Ford were the primary authors of most of the creative materials incorporated into both Star Control 1 and 2, including the game design, story art, sound effects, software code, and other materials. Specifically, Reiche created the names, initial concepts, written descriptions, and sketches of every character in the game, as well as their history, physical and cultural details, and conversation design and text specification. As far as defendants recall, Ford wrote all of the code for both Star Control 1 and 2. Star Control 1 was printed with copyright 1990 Paul Reiche and Fred Ford, and Star Control 2 was printed with copyright 1992 Paul Reiche and Fred Ford. Later, in December 2017 and April 2018, Reiche and Ford obtained U.S. copyright registration numbers, respectively, for the computer program code and audiovisual content of Star Control. In 1995, Reiche and Accolade executed an addendum number 2 to the license agreement to allow Accolade to develop a third Star Control game without Reiche and Ford's involvement. Pursuant to Addendum 2, Reiche granted Accolade the right to use and modify all characters, names, likenesses, characteristics, and other intellectual property rights pertaining to Star Control 1 and 2 in which he has an ownership interest, in exchange for the payment of an advance and royalties. Accolade published Star Control 3, the Kisari Quadrant. Pursuant to the license agreement, Accolade owned the copyright and all other proprietary rights in Star Control 3, subject to Reiche's copyrights in Star Control 1 and 2. Accolade obtained U.S. copyright registrations for Star Control 3, covering its computer code and audiovisual content. It also obtained U.S. trademarks for the Star Control mark. This is very important. Reiche, Ford, and Accolade entered into further negotiations and agreements, but no other Star Control sequels were released. By 2000, Accolade and its successors stopped paying Reiche and Ford royalties for the classic Star Control games. Thus, according to Reiche and Ford, the license agreement and all subsequent addenda expired and terminated by April 1st, 2001. In 2002, Reiche and Ford released an open-source edition of Star Control 2, which was free to use in a non-commercial context. Because Reiche and Ford could not obtain the rights to use the Star Control trademark, the game was released as the Urquan Masters. According to Reiche and Ford, they had long planned to develop a sequel to the Urquan Masters. On October 9, 2017, Reiche and Ford publicly announced their plan to develop a sequel titled Ghosts of the Precursors. In 1999, Atari acquired Accolade. In or about 2013, Atari filed for bankruptcy and put up for sale its assets, including the Star Control franchise, described as Star Control 3. In July 2013, Stardock and Atari executed an asset purchase agreement whereby Stardock paid $300,000 for Atari's rights in the Star Control IP. According to the list of intellectual property attached to the purchase agreement, that included the Star Control trademark and the Star Control 3 copyright. Stardock claims that it also purchased the exclusive publishing rights to Star Control 1 and 2 under the license agreement. Reiche and Ford dispute this claim, asserting that A, the license agreement expired, and B, all rights under the license agreement reverted to Reiche by virtue of Atari's bankruptcy, and C, the license agreement could not be assigned without Reiche's consent. In 2013, after acquiring Accolade's Star Control IP, Stardock began developing a new game, Origins. Around that time, Stardock's CEO, Bradley Wardell, contacted Reiche and Ford. Wardell now avers that he offered Reiche and Ford the right of first refusal to collaborate on the development of Origins. The correspondence between Wardell, Reiche, and Ford tells a different story, however. In or about July 2013, Wardell contacted Reiche and Ford seeking to license the Star Control universe for Origins. Reiche and Ford made clear that they hold the copyrights to Star Control 1 and 2, and Wardell acknowledged the same. Reiche and Ford declined to execute a license, stating that they would like to work on their own Star Control project in the future. Thereafter, Wardell repeatedly assured Reiche and Ford that Stardock would not be making use of any Star Control 1 and 2 IP, which in this case means alien names, alien designs, lore, art, music, and ship designs, without their express permission. The new game, quote, won't be including the Star Control classic aliens and lore. Through at least August 2017, Wardell also continued to request a license for some or all of the Star Control alien IP and such. This included a proposed re-release of Star Control 1 and 2. Reiche and Ford consistently declined all such offers. In or about October 2017, Stardock changed its position regarding the Star Control 1 and 2 IP. Stardock began selling Star Control 1 and 2 on its website and on Valve's video game platform Steam. There's a footnote 4 here. In late 2017, Reiche and Ford sent Valve a notice of copyright infringement under the DMCA regarding their sale of Star Control 1 and 2. It also began taking pre-orders for Origins and releasing promotional content. On or about November 16, 2017, Stardock released a promotional minigame titled Star Control Origins Beta 1 Fleet Battles. Stardock also released promotional content packs, including the Chenjesu Content Pack and the Aralu Content Pack. The promotional content was made available on GOG and Steam platforms. As set forth in more detail below, the instant action commenced in December of 2017. In or about March of 2018, Wardell publicly stated that Origins will include the aliens from Star Control 1 and 2, and on June 11, 2018, Stardock publicly announced the official release date for Origins as September 20, 2018. Between March and August, Wardell confirmed that Origins will include classic Star Control aliens, including the Aralu and Chenjesu. The Aralu and Chenjesu content packs also include those aliens, which Reich and Ford allege are substantially similar to or derived from aliens of the same name in Star Control 1 and 2. Stardock's website includes images of other aliens, including the Yahat, Spathi, and Ors, which Reich and Ford allege are substantially similar to or derived from aliens of the same name in Star Control 1 and 2. On August 17th and 21st, Reich and Ford sent Valve and GOG notices of copyright infringement under the DMCA regarding Fleet Battles and the Chenjesu and Aralu content packs. As a result, Valve and GOG removed the promotional content from their respective platforms. On August 20th and 27th, 2018, Stardock sent Valve and GOG counter notices under the DMCA. The promotional content remained unavailable on the Valve and GOG platforms. Thereafter, Stardock requested that Reich and Ford withdraw the DMCA notices. Reich and Ford refused and reserved the right to serve further DMCA notices in response to additional infringing content. Stardock anticipates that Reich and Ford will send DMCA notices to GOG and Valve regarding Origins. According to Stardock, Origins does not include any copyrightable artwork from the classic Star Control games. Stardock asserts that any DMCA notices directed at Origins will cause immediate and irreparable harm. This is the standard for a preliminary injunction. Together, the GOG and Steam platforms represent approximately 93% of Stardock's distribution channels. Stardock contends that if the Origins release is interrupted, significant resources will have been wasted and its reputation in the marketplace will be harmed. Specifically, Stardock has spent between $9 and $10 million developing Origins. Marketing has been underway since June 2018, and Stardock has spent hundreds of thousands of dollars promoting Origins. According to Stardock, the release of Origins was widely communicated to Stardock's customers, partners, and press. As early as September 2018, approximately 10,000 customers had pre-ordered the game. Stardock asserts that if a DMCA notice is issued, Origins will have been promoted and released, but seemingly operating under the assumption that GOG and Valve will remove the game from their platforms, it will no longer be available for purchase or play on the distributors' platforms. Stardock contends that the rumored suggestion that Origins will not be released has already led to backlash from Stardock's customers who have pre-ordered the game and then requested a refund. Stardock also asserts that the issuance of a DMCA notice will negatively impact its business relationships, including its ability to partner with a game console publisher for Origins. On December 8, 2017, plaintiff filed a complaint against defendants for trademark infringement, copyright infringement, and related claims. Defendants filed an answer as well as counterclaims against plaintiff for copyright infringement and related claims. In the meantime, plaintiff filed the instant motion for a temporary restraining order and an order to show cause why a preliminary injunction should not be granted, wherein it seeks an order enjoining defendants from submitting any further DMCA notices directed to material that is the subject of the present litigation and, in particular, Origins. The parties then executed a stipulation and proposed order for interim relief with a proposed briefing schedule which the court adopted. Pursuant to that stipulation, defendants agreed not to file any further DMCA notices pending resolution of the instant motion. The motion is fully briefed and ripe for adjudication. Then the court goes into the legal standard for a preliminary injunction. The purpose of a preliminary injunction is to preserve the status quo during litigation pending a determination of the action on the merits. A preliminary injunction is an extraordinary remedy, never awarded as of right. Rather, it demands a clear showing that a movement is entitled to such relief. The party seeking a preliminary injunction must show that 1. It is likely to succeed on the merits, 2. It is likely to suffer irreparable harm in the absence of an injunction, 3. The balance of equities tips in its favor, and 4. An injunction is in the public interest. A preliminary injunction must also issue if there are 1. Serious questions going to the merits, and 2. The balance of hardships tips sharply in the movement's favor. Either way, the moving party must make a showing on all 4 prongs and bears the burden of demonstrating that a preliminary injunction is warranted. So the court goes into some of the submissions that were done. There was a bunch of declarations and objections. So plaintiffs submitted a declaration by Wardell, and there were objections to that. Defendants filed a declaration by Reiche, and there were objections to that. Plaintiff filed more declarations by Wardell and David May and Robert Weichert, and there's eventually objections to that. The court notes that a preliminary injunction is customarily granted on the basis of procedures that are less formal and evidence that is less complete than in a trial on the merits. Consequently, the federal rules of evidence do not strictly apply to preliminary injunction proceedings. Here, the parties' objections offer little of substance as to the weight of the evidence, which the court can easily assess without the aid of the parties' arguments. Many of the parties' objections are frivolous. For example, plaintiff objects to Reiche's declaration, "I created the concept for the Star Control video game," on the ground that it lacks foundation. Clearly, Reiche has personal knowledge as to what he did or did not create. On the other hand, the merit of other objections is obvious. For example, defendants object to Wardell's declaration that Stardock has not incorporated any copyrightable artwork from Star Control 1, 2, or 3 into the Origins game itself, on the ground that Wardell lacks the expertise necessary to opine as to what constitutes copyrightable artwork. Indeed, not only has Wardell failed to establish any such expertise, but his opinion as to whether the work in question is copyrightable constitutes an improper legal conclusion. Such legal conclusions are without evidentiary value. In view of the foregoing, the court hereby strikes the parties' non-compliant filings. Notwithstanding the striking of the parties' respective objections, where evidence bearing on the resolution of the instant motion lacks or is of limited evidentiary value, the court will so note. Plaintiff moves for a preliminary injunction to enjoin defendants from filing further DMCA notices directed to the material that is the subject of the instant litigation, and, in particular, Origins. Plaintiff's justification is twofold. 1. The issuance of a DMCA notice is tantamount to an injunction, for which defendants have not made the requisite showing under Winter. And 2. Alternatively, plaintiff itself satisfies the standard for a preliminary injunction under Winter. The court addresses these arguments in turn. 1. Defendant's issuance of a DMCA notice is not an injunction. Congress enacted the DMCA in 1998 to comply with international copyright treaties and to update domestic copyright law for the online world. Title II of the DMCA, known as the Online Copyright Infringement Liability Limitation Act, or ACILA, created 4 safe harbors that protect service providers from liability for claims of copyright infringement based on the actions of their users. Title II does not alter the standards for liability under the various doctrines of direct, vicarious, and contributory copyright infringement. Rather, Title II limits the relief available principally by precluding monetary relief against service providers that qualify for one or more safe harbors. As is pertinent here, Section 512C limits the liability for infringement by reason of the storage of material that resides on a system or network controlled or operated by or for the service provider, where said storage is at the direction of the user. There are a number of requirements a service provider must satisfy to receive 512C safe harbor protection. Footnote 8 says, "The court lacks sufficient information upon which to determine whether the safe harbor, in fact, applies here. For purposes of this instant motion, however, the court assumes, arguendo, that GOG and Valve satisfy the general requirements for safe harbor. Among other things, a service provider must not have actual or red flag knowledge of the infringing material. Upon obtaining such knowledge or awareness, a service provider must act expeditiously to remove or disable access to the material. If invoked by a copyright holder, a service provider must also comply with the DMCA's notice and takedown process. This is from Rossi v. Motion Picture Association of America, a Ninth Circuit case in 2004, and this explains a lot of DMCA abuse on YouTube. It's not a process where the content host gets to evaluate the DMCA. No, the content host is protected only if they act on it, only if they comply with the takedown process. And here it is. Under the DMCA's notice and takedown process, a copyright owner must provide written notification to the service provider identifying the work claimed to be infringed and the material claimed to be infringing. The service provider, upon notification of claimed infringement, must expeditiously remove or disable access to the allegedly infringing material and promptly notify the affected subscriber. The affected subscriber may then submit a counter-notification asserting a good faith belief that the material was removed or disabled due to mistake or misidentification. Upon receipt of a counter-notification, the service provider must promptly notify the copyright holder and replace or restore access to the allegedly infringing material within 10 to 14 business days, unless the service provider first receives notice that the copyright holder has filed an action seeking a court order to restrain the subscriber from engaging in infringing activity related to the material on the service provider's system or network. There's the lawsuit part of it. The original copyright owner who's claiming things through DMCA must follow the procedure, must issue a either notification or counter notification, and if there's a counter notification, the DMCA sender must go to court over it in order to keep the thing out of sale or off the marketplace. And that's what they've done here. We have this litigation going on, which should be keeping any of these DMCA notices, and the material should be being kept off of GOG and Steam during the litigation. Footnote 9 says, Title II creates a cause of action for material misrepresentations made knowingly by a copyright holder or service provider in connection with a DMCA notice or counter notice. Plaintiff has brought such a claim against defendants regarding their filing of DMCA notices for the Origins promotional content. Here, asserting that the issuance of a notice of infringement will result in the removal of Origins from the GOG and Steam platforms, plaintiff argues that defendants' use of the DMCA notice and takedown process constitutes a backdoor or self-help injunction without the requisite showing to obtain such relief. Likening the DMCA notice and takedown process to the impoundment of virtual goods, Stardock argues that, as applied here, it is at odds with the requirements of Rule 65 and violates due process protections. To bring the DMCA in harmony with Rule 65, plaintiff urges the court to maintain the status quo until the copyright issues central to this litigation may be determined on the merits. In other words, plaintiff contends that defendants should be enjoined from issuing a notice of infringement that seeks removal of Origins from the GOG and Steam platforms unless and until defendants file a motion to obtain such relief in this action. Plaintiff's threshold argument is uncompelling. Plaintiff's argument is based on the flawed premise that the issuance of a notice of infringement under the DMCA is the equivalent of an injunction requiring the removal of allegedly infringing material. It is not. Defendants cannot unilaterally block Origins or any other content from distribution by issuing a DMCA notice. Such notice simply serves to provide knowledge of alleged infringement to service providers. Critically, receipt of a notice of claimed infringement does not mandate that a service provider remove or disable access to allegedly infringing material. Rather, in providing safe harbor from liability, Title II of the DMCA incentivizes service providers to remove infringing material. Title II of the DMCA contains a number of measures designed to enlist the cooperation of Internet and other online service providers to combat ongoing copyright infringement. Title II provides strong incentives for service providers and copyright owners to cooperate to detect and deal with copyright infringements that take place in the digital network environment. Plaintiff acknowledges as much. Service providers have every incentive to take down targeted content, they've said. Plaintiff claims that the loss of Section 512's safe harbor proves too great an incentive for service providers, causing them to take down targeted content immediately, regardless of the merits or lack thereof of a takedown request. Insofar as plaintiff questions the wisdom of the DMCA process, however, its quarrel is with Congress, not this court. Title II of the DMCA grapples with difficult and controversial questions of copyright liability in the online world. The notice and takedown process is a carefully considered protocol, which strikes a balance between the competing interests of various stakeholders. Whether that balance would benefit from recalibration is a matter for Congress to decide. For purposes of the instant motion, the court is satisfied that the DMCA notice and takedown process is not tantamount to an injunction. Furthermore, plaintiffs claim that third-party service providers such as GOG and Valve act instinctively to remove material claimed to be infringing, regardless of the merits of the claim, is overstated and without basis, at least as applied to the instant case. Plaintiff provides no evidence to support its assertion that GOG and Valve remove content regardless of the merits of a claim of infringement. Based on the evidence provided to the court, it appears these service providers benefit financially from the sale of games that occur on their respective platforms. Thus, these service providers are not disinterested actors, nor are they uninformed actors. The court notes that GOG and Valve are parties to this action and already have notice of the claims of infringement being asserted by defendants. Notably, if defendants' claims of infringement prove successful, GOG and Valve are already at risk of forfeiting any safe harbor protection under Section 512C if they continue to offer origins. Section 512C1A requires a service provider with actual or red flag knowledge of infringement to act expeditiously to remove the material. To maintain its shield, a service provider must delete or disable access to known or apparent infringing material as well as material for which he receives a statutorily compliant takedown notice. In view of the foregoing, the court will not enjoin defendants from filing DMCA notices based solely on defendants' failure to satisfy the standard for injunctive relief. The court goes on, plaintiff is not entitled to a preliminary injunction. Defendants oppose plaintiff's motion for a preliminary injunction on various grounds, including 1. That a preliminary injunction will upset the status quo, not maintain it. 2. Plaintiffs face no irreparable harm. And 3. Any harm is of plaintiff's own making because it chose to release origins during the pendency of this action. As discussed below, the court finds defendants' arguments persuasive. The purpose of a preliminary injunction is to preserve the status quo during litigation pending a determination of the action on the merits. The status quo during litigation refers not simply to any situation before the filing of a lawsuit, but instead to the last uncontested status which preceded the pending controversy. Defendants argue that the requested injunction would upset the status quo, not preserve it. Plaintiff does not respond to this argument. This is fatal to its motion for a preliminary injunction. Here, the status quo ante litem involves plaintiff's development of a new game within the Star Control universe based solely on its Star Control IP and without making use of the material covered by defendants' rights in Star Control 1 and 2. Upon learning of plaintiff's intent to develop Origins, defendants stated that they hold copyrights to Star Control 1 and 2. Plaintiff acknowledged the same and repeatedly sought a license to use the Star Control 1 and 2 IP in Origins. Defendants declined. Through at least August 2017, plaintiff assured defendants that Origin would not make use of any Star Control 1 and 2 IP. Plaintiff ultimately changed his position, however, and a copyright dispute materialized in the fall of 2017. Plaintiff now asserts that defendants have no protectable interest in Star Control 1 and 2, and that its use of Star Control 1 and 2 in Origins does not constitute infringement. Notably, Origins had not been released, nor had its release date been announced when the instant action commenced in December 2017. Under these circumstances, preventing defendants from filing any further DMCA notices in response to the release of potentially infringing content, including Origins, would not preserve any semblance of the last uncontested status that preceded the present litigation. Indeed, it would go far beyond preservation of the status quo by protecting plaintiffs' release of the potentially infringing Origins game, development of which was in its infancy, or at the very least did not incorporate any of the Star Control 1 and 2 IP at the time of the last uncontested status prior to this litigation. Indeed, plaintiff seeks not to simply release purportedly infringing material during the pendency of the action, but to foreclose defendants from exercising their statutory right to issue a DMCA notice of infringement in response. This is inequitable and would turn the status quo doctrine on its head. An alleged infringer cannot release purportedly infringing material in the midst of litigation and then reasonably ask the court to hamstring the alleged copyright holder in its efforts to curb the alleged infringement. This factor alone supports denial of a preliminary injunction. As set forth below, an analysis of the irreparable harm prong further supports the court's conclusion. Plaintiff claims it will suffer irreparable harm if the defendants are able to utilize the DMCA notice takedown procedures to sabotage the release of Origins. Plaintiff's purported injury takes the form of lost revenue and reputational harm. As a threshold matter, the court finds plaintiff's evidence in support of its claim of irreparable injury wanting. Plaintiff's claim depends on the unsupported assumption that GOG and Valve will remove Origins upon receipt of a DMCA notice of infringement. Although plaintiff enjoys contractual relationships with GOG and Valve, who are also party to this action, it offers no evidence in the form of a declaration or otherwise that GOG and Valve will act to remove Origins. Further, even assuming Origins will be removed, the evidence of irreparable injury is inadequate. Economic injury alone does not support a finding of irreparable harm because such injury can be remedied by a damage award. Therefore, plaintiff's loss of revenue alone does not support a finding of irreparable harm. Cognizant of this fact, plaintiff asserts related intangible injuries, such as damage to its business development strategy and ongoing business relationships, finding a console partner for Origins. The only evidence offered in support of these claims are the conclusory statements of its own executive, however. This is insufficient. The court agrees with defendants that the threatened harm is of plaintiff's own making. If the harm complained of is self-inflicted, it does not qualify as irreparable. Because the movements acted to permit the outcome which they find unacceptable, we must conclude that such an outcome is not irreparable injury. Harm does not constitute irreparable injury if it is self-inflicted. As aptly observed by defendants, Stardock announced the release date and launched its marketing campaign for Origins in June of 2018, long after this case was at issue and Stardock was well aware of Reich and Ford's allegation that Origin infringed their copyrighted work. Stardock did nothing to avoid the purported risk of irreparable harm that it now bases its motions on, and Stardock announced the release of Origins in the middle of this case and ramped up its spending. Plaintiff does not directly respond to this point. Further scrutiny of its alleged harm supports defendants' arguments, however. Plaintiff asserts that it stands to lose substantial monies spent on the development and marketing of Origins. Plaintiff was aware of defendant's copyright claim to Star Control 1 and 2 since the development of Origins commenced, however, and was aware of the contours of the present copyright dispute since at least December 2017. Thus, whatever monies plaintiff invested in Origins was done with the knowledge that serious copyright disputes were likely to arise or had arisen. Plaintiff further asserts that the release of Origins had been widely communicated to Stardock's customers, partners, and the press, and that any disruption of its release will be injurious to plaintiff's reputation. Again, plaintiff announced the release of Origin in June 2018, 6 months after this action commenced. Plaintiff thus invited reliance on its announcement regarding the release of Origins with knowledge of defendants' claims. In view of the foregoing, the harm plaintiff complains of is indeed of its own making. Plaintiff had knowledge of defendants' copyright claims from the outset. It developed potentially infringing material without resolution of the IP ownership issues, and then publicized the release of that material during the pendency of this action. It now claims that its investment in Origins and reputation are on the line. Given that plaintiff largely created the foregoing predicament, the court is disinclined to extricate plaintiff from a peril of its own making. The court is ill-inclined at this late hour to pull the plaintiff's chestnuts out of a fire sparked by its own ill-fated tactical decision. In sum, plaintiff has not made an adequate showing on the second and third prongs of the preliminary injunction standard. Plaintiff has failed to satisfy its burden to obtain preliminary injunctive relief, and the court need not address the remaining prongs. In conclusion, and for the reasons stated above, it is hereby ordered that plaintiff's motion for a preliminary injunction is denied. This order terminates docket number 56. Sandra Brown Armstrong, Senior United States District Judge. December 27th, 2018. So this just happened 4 days ago. And I think this is really, truly remarkable. The convoluted story of how we got here. If you watch my video from a year ago, I really couldn't have told you, and I probably couldn't have figured it out without being one of the lawyers involved in the case, what was going on here. So this is a great summary of how the DMCA process works, what happens with Reich and Ford in issuing DMCAs, and how Brad Wardell can't just release a Star Control Origins which contains copyrighted material from Star Control 1 and 2 without permission from Reich and Ford. So maybe that clears up a little bit how the whole Atari, Accolade, Reich and Ford agreement, which was then Atari or Accolade's stuff was purchased by Brad Wardell. Like, what did he actually purchase? Apparently, he really only purchased the computer code and a trademark, but can't use the underlying characters or lore or anything like that. So that's really interesting. We've seen some very strange tweets from Brad Wardell trying to flip this on the other side, saying that, well, obviously the DMCA process is broken. Look, even the court said you have to talk to Congress. Well, yeah, that's true. He's saying that because Brad Wardell is wrong, not because Reich and Ford are wrong. So with that context, go back and read some of these tweets from Brad Wardell and see how you feel about them now. So here's one. Just a heads up, Paul Reiche has filed a DMCA takedown notice to GOG claiming that Star Control Origins violates unspecified copyrights within Star Control 2. And this was sent on December 31st. Well, it sounds like Brad knew about this for a very long time before this, according to the court here. Here's another one. The courts have already ruled that if you don't like the DMCA law, write your congressman. Which almost sounds like he's asking for sympathy, but here, the reason the court said that was that Brad was trying to say, oh, a DMCA is like an injunction, and you shouldn't be able to send one during litigation. And the judge said no to that. Here, somebody asks a question about how Brad acquired the Star Control IP, and here, just yesterday I believe this was, he said that he acquired it from Atari, who bought Accolade. And then the question comes back, so when it was purchased, everything was on the up and up and there was none of this bullshit? And Brad says, correct. Everyone understood what was acquired. However, obviously Brad didn't understand what was acquired because the judge was much quicker to grant Reich and Ford's request than grant Brad Wardell's request for a preliminary injunction. And then finally, he adds one additional point. Reich and Ford did not start claiming that Star Control Origins itself had copyright issues until around 90 days before release. Their initial complaint was for the sale of Star Control 2. Origins had nothing to do with Reich and Ford. Well, that's fine and that's possible, but it also seems like the court didn't think so. The court saw the declarations of everybody, and the court seemed to think that Brad Wardell knew that he wasn't allowed to use Star Control 1 and 2 or its lore, or characters, etc., all the way back in the beginning, and then Brad changed his position recently. So that's really interesting stuff. I really don't know what Brad's thinking here. It seems like he's out over $10 million worth of development costs, and and marketing and all that. Hopefully, some of that can be reused into maybe a game that doesn't infringe on Star Control 1 and 2. And I'm sure that we'll hear much more about this whole thing, as this is just a preliminary injunction. This is the very beginning of a court case. I know it's a year into it, but we're still at the very beginning of a court case, and we're about to enter the part where they get prepared for trial and go to a trial, and then they can really have it out, and usually a judge, but it could be a judge or jury. Someone has to be a fact finder and determine what is true and what's not. And I don't really have the time to go through hundreds of documents and figure out the nitty-gritty of all this. So we wait sometimes for the judge and the judge's staff to figure it out. So I'll definitely have an update for you as this case unfolds further. Maybe the parties will settle at some point, or maybe Reich and Ford and Wardell won't be able to settle, and they will really have to go through a fact-finding trial to figure out who's right and who's truly wrong. So what do you think of that? Definitely leave your thoughts in the comments below. Let us know if you're disappointed that Star Control Origins isn't coming out, or if you think that it's a good thing that Brad has to go and remove anything that doesn't belong to him and release his game that way. I'm personally on the side of Reich and Ford so far, but it's more like I like a soccer team or a football team than I know who's right and who's wrong in this one. The only legal inclination I have to agree to somebody is that the judge seems to think that Reich and Ford are on the right side of this and that Brad Wardell is not. So we'll see what happens there. Oh, you know what? I don't have the new Patreon list. I just realized it is the first. It is 9:17 a.m. Eastern time, and I'm not sure that I have my Patreon reward list yet. I'll read off the names as they exist here. Our $50 plus supporters for the month of January. Thank you very much to Jonathan Doe, Daniel Perez, Spirit Bear, Jan Negrey, Richard Fournier, Terry Crisp, Michael Pearce, Verement, Tayne, Kyle Mudrak, Andy, Eevi, Gavin Barnard, and John Steele. Very sorry that's out of order. I usually like to do it according to age of donation, so that the people who have been donating for the longest period of time come first. It just is out of order because Patreon is currently processing that list. And thank you to the, let's see, how many Patreon donors, supporters are we up to now? Thank you to the 380 of you who are supporting us at $1,800 a month in donations to make these videos possible. As you are well aware, I am a copyright attorney. I am Leonard French. I am a real licensed attorney in the US, and to take the time to make these videos, I'm taking a pretty severe pay cut. People who practice fully can easily make $150 to $350 or more $1,000 a year. People who run their own practices and things can easily hire staff and make very, very good six-figure incomes. And instead, I'm taking more than half of my time to develop these videos for you for approximately this amount of money. So we're very grateful for that opportunity, and I want to keep doing this, but I do want you to know that we need your support. I am not some independently wealthy attorney who is living off of a trust account, otherwise financially solvent. This is my income. This is how I survive. You may think that's sad. You may think that's great. I personally think it's an awesome opportunity for me, and I'm very grateful for that. This is the year, 2019, that I expect to turn this into some sort of 501c3 charitable legal services organization or something. Somehow we'll figure out how to get your donations converted to tax-deductible donations when the appropriate time comes, and hopefully this will help me solve my $300,000 in student loans problem. So I'm just trying to bring a little bit of reality to what I'm doing here, in the hopes that everyone will understand why I ask for money and that I'm not just some cheapskate who's trying to get a free buck. So I really appreciate that you've made all this possible. Without your support, I wouldn't be here seeing my girlfriend in Scotland and making videos here for you from Scotland. So that's really cool. I'll see you in the next video. Love you all. I'm Leonard French, your favorite copyright attorney. Have a great year. Insofar as plaintiff questions the wisdom